nope, we're not doing this, we're not divorcing.
Oh, right. So I'm not advocating for
Yeah,
for
let's hear it,
causing
though.
delays. Then you will be sanctioned.
And the odds aren't in your favor that
Yeah.
day.
That's it. There is no smoking gun. So it's almost like you could be kind of silenced or there will be a divorce today.
I'm MaryJ, your divorce realtor, and this is UNCoupled. I'm here with Maiya Safikovs, family law attorney. How are
Hello.
you?
Hi, MaryJ. I'm well. How are you?
I'm great. Things have been so crazy these days. How are things for you?
I'm doing well. My
Good.
practice is doing well. What about you and the housing market?
Great. So many people have shown interest now that we've got spring coming up. This is the time for folks to list their house, so it's getting busy. It's
It
getting
is.
very busy.
The spring season is the best season. Is that correct?
It is. I always kind of think of like winter as folks laying dormant the same way animals do. We kind of start to prepare a home. So I think of the whole real estate journey of a home seller as the seasons. You know, you use the winter to prep, and then once spring hits, you got to be ready to go. So, all right. And today we're talking about filing a response, the person who gets served, what is that like for them? I also want to talk about some delay tactics because we know we got plenty of those. So I'm hoping that we can cover all of that. And so let's just get started.
Sure.
Okay. So let's say, Maiya, that someone files a divorce and they're served, but the other party does not agree with the divorce. Is there a legal way to actually refuse it, like stop the divorce or just say, nope, we're not doing this, we're not divorcing?
No. Either party has the right to have a divorce in Georgia. We have ground number 13. There in Georgia, you have to have a reason for a divorce, but ground number 13 in our statute is that the marriage is irretrievably broken and there's no hope of reconciliation. So if a party wants a divorce, then he or she will get it. The only
Okay.
way to stop the divorce is if you all get back together and if you have intercourse and you take the divorce. Yeah.
Let's
spoke
talk about that one.
Sure. So once you file for divorce, you must stay in a bona fide state of separation. That means that you can no longer have relations. If you have sexual relations, then during the pendency of the divorce, then the divorce has to be dismissed and refiled.
Got it. So any sign of reconciliation, if the judge gets wind of this, they're going to tell you to go reconcile. They're going to consider that a breach of the separation.
Only if there's intercourse.
Got it.
Right. So it's very common, especially in this housing market. It's very common for parties to continue to cohabitate with one another.
True. Yes.
That's to be expected. But it's not to be expected that you and your soon-to-be divorced spouse are to continue to have intercourse with one another during the process.
No, that makes sense. Okay. So there's no way to really stop the divorce, even if you don't agree. The person needs to do what? They just need to respond.
So once you are served with a summons and the complaint for divorce, you have 30 days from the date of service to file your answer.
Okay.
That answer, and typically an answer and a counterclaim. So your answer is going to be your response to the petition or the complaint for divorce.
Okay.
So you will answer each of those numbered paragraphs in the complaint for divorce. You may also have a counterclaim. I highly recommend a counterclaim.
Okay. Why?
That is your own independent lawsuit against the other party.
Interesting. I never thought of it like that.
So if you only answer and your spouse subsequently decides, I don't want the divorce anymore, I'm going to dismiss the divorce, the whole action goes away. However, if you file a counterclaim, then you have your own independent action on which you can still have some say-so in the divorce proceedings.
Hang on. So you mean to tell me that a person can file a divorce and you can file your own divorce by just simply having a counterclaim?
Yes, that's what it is. It's a counterclaim action.
Got it.
So, and I've had this happen where one of my clients, for religious purposes, after we filed for divorce, he decided that he did not want to go through the divorce process any longer. So we dismissed. However, the divorce action still proceeded because his wife filed a counterclaim. So initially, the style of the case was husband versus wife. Once we dismissed our action, then it became wife versus husband.
Amazing. Something you would never know.
And so you need that protection. That's why you need to have your own separate answer and counterclaim, because tables turn. You may enter a divorce not wanting the divorce, but then you may see some things, especially through a process known as discovery, which we'll get into soon. But throughout the divorce process, your eyes could be open, your emotions could shift, and you could determine that you really want the divorce. You want to be able to still have a say-so and have your own divorce action if your spouse were to subsequently dismiss.
Got it. Amazing. You're just such a wealth of knowledge.
So
That's why I
are
love
you,
having you on
Mary
the
J?
show. All right. So what if, let's just say, you always have folks who love to delay things
Yes.
because maybe they're not ready for divorce. So what are the delay tactics that people try to use during the response period? And, what if they just completely ignore everything? Is this something you see commonly done?
Yes. So, discovery, what I just mentioned, discovery is a 6-month period in Georgia where we have the ability to request and exchange information. So this could be financial documentation, bank accounts, taxes, W-2s, income statements, 401k, pension statements, all of that can be exchanged and requested during that time period. The most delays are seen in the discovery process or the abuse of the discovery process. So typically you're served with a request for production of documents or interrogatories. And if the other side if you don't comply, then it can elongate the process. Also, another way to cause delays, or that delays are caused. I'm not advocating for,
Yeah,
for
let's hear
causing
it though.
delays. But another way that delays are caused are by not attempting to settle in good faith.
Oh,
Right. So at the onset, some attorneys and some parties will go and want to engage in settlement negotiations. And if you fail to respond or fail to engage in those, then you could be accused of causing delays and elongating the process.
just because you don't want to settle or
Well, you don't have to settle,
Okay.
but the courts do want for you to look at alternative methods to resolve disputes.
so good faith, like
Yep.
effort. You have to put in
And so
some
just to
effort.
see, that's grounds for attorney's fees. If another side sends a settlement offer to you, and that settlement offer turns out to be in line with what the judge ultimately orders,
Yeah.
then the other side can recoup attorney's fees from you.
Got it.
Then a number of our jurisdictions here in this state require mediation before you can get to a final hearing.
Okay.
If you refuse to comply with the scheduling of the mediation, then that could cause delays. That's frowned upon, and that can be brought to the attention of the court during the litigation, the end of the litigation. So because judges want to move cases along,
Yeah.
they want to give some type of resolution and resolve for these families.
Right.
There are sanctions if you cause unnecessary delays.
Ooh, what are the sanctions?
Most of the time, they're financial sanctions, such as attorney's fees.
Okay, hit
So
'em
we
where it
have-
hurts.
Yes. And so if you unnecessarily elongated a proceeding,
Yeah.
then you could be liable to the other side for his or her attorney's fees.
Got it.
There can be sanctions when we talked about discovery abuses. There are other sanctions that are non-monetary, such as the striking of your answer or the striking of defenses that you are attempting to assert. A court could opt to punish you by doing that if it's determined that your behavior has been so egregious.
What does that mean, really? What
So-
does that look like in court?
In court, it means that basically if you're filing an answer and a counterclaim, your counterclaim could be stricken, and you're just going forward on the other side's case.
Wow.
And that's it. And so it's almost like you could be kind of silenced by the court
Wow.
for engaging in bad behavior. So Georgia courts don't play when it comes to discovery. We operate above board. There is no smoking gun. everything must be disclosed if you properly request that information.
Got it.
So there can be no hiding of assets during a divorce process.
Yeah.
And if it's discovered that you have done so, or it's discovered that you have caused delays by trying to do so, then you will be sanctioned.
Wow. So let's just keep it upstanding
Yep.
and keep, I love that. It's actually good because I know a lot of, I have a client today who, you know, their significant other took them through, and is still taking them through huge delay tactics. And, even to the point where their case, that person is filing a motion to try to um, dispute it. The
Yeah.
divorce has been settled, but they're trying to file a motion to dispute the settlement.
Oh, to set it aside.
Yes.
Yeah. And so if they're unsuccessful, then that person who's trying to file that motion, they open the door for exposure to have to pay the other side's attorney's fees.
Yeah. That's something. People really do go through a lot.
Mm-hmm.
Um, and so I guess what's the craziest delay tactic you've ever seen?
My client's wife did not want to get divorced, so she refused to cooperate with everything. She did not have an attorney, but she refused to go to mediation. She refused to turn over discovery. She refused to do everything.
What does that refusal look like? Is it
She was unresponsive. But courts recognize that individuals will do so. So because we had the requirement that we had to go through mediation, we were able to file a motion and to attach all of our attempts to try to get her to hammer down a day for us to have mediation, in
Got
which
it.
she was unresponsive. And the court ultimately allowed us to waive and bypass mediation and to proceed with a final hearing.
okay?
Her refusal to respond to discovery, that meant we didn't have any of her financial information. My client was just done, so he was like, I don't think she has that much anyway, and I want to keep mine and she keep hers. And so we were able to just proceed with the final hearing. And she showed up to the final hearing, and she was very transparent to the judge that she
So
did
she was
not
getting
want
the
a divorce.
notices if she knew about the final hearing.
Yes, she was very transparent. She did not want the divorce. And the judge had to tell her about 8 times, ma'am, there will be a divorce today.
Wow. So that goes back to you cannot stop this
Yes,
thing.
you cannot stop
just
it.
because you don't want it.
Yep.
Interesting. So, okay, let's say you're the other party who is filing the response and you don't have an attorney. So you're doing the best you can, and you make a lot of mistakes in the paperwork. Does the judge care about, mistakes? Is there something that could invalidate your response? Um,
In a divorce, there's a lot of leeway.
okay.
So that's because we can amend pleadings. So I will often get hired by people who are representing themselves in a divorce, and then it gets too hot and heavy, so they decide that they need counsel.
So are you going in like a teacher, fixing all
Yes,
the mistakes?
we go and we have to amend the pleadings. And the number
Okay.
one error that could be extremely detrimental at trial is if they don't ask for certain things in their pleadings. So if you don't specifically plead for custody, like if you want custody of your children, and you don't state that you want primary physical custody, then you cannot get it. Also, if you don't state that you want alimony, you cannot then petition the court for alimony. And if you don't state that you want reimbursement of attorney's fees, you cannot have reimbursement of attorney's fees.
Wow.
That's because all of these factors must be specifically pled so that the other side can prepare his or her own case in defense or support thereof.
Okay, got it. So that is important. All right, and then just say the person they deny everything in their response. So is that is that considered strategic, or can I deny everything? Like if I were to just go in and deny, that's my response. What's the worst denial?
So
How does this affect someone?
denying everything it will make you look flippant to the court, like you just don't care. you're not taking the process seriously. So
Yeah,
judges
I can see that.
look at everything before your hearing, before your final hearing. Your file is brought up from the clerk's office, and the judge and his or her staff attorney reviews the entire case file.
I would love to be in the background on those days. I know it's a party. I know it's a laughing party
Yes.
sometimes.
So they look at the complaint that was filed. They look at the answer. They look at any subsequent motions. They're aware of
Long
everything.
before you show up that day.
Yes. And a few weeks ago, when we spoke about service, remember we talked about getting served by a process server?
Yes.
Well, process servers must submit affidavits of service, right? And
Okay.
so those affidavits of service will detail the fact that they perfected service, the date and time, when they perfected service, the location, the identifying factors of the party, and then they will go into detail about what happened.
Wow.
So if you acted a fool,
Mm.
it may be put in the affidavit of service, and the judge who is going to preside over your case will be able to see that because that affidavit of service is filed in your
So they
lawsuit.
can already know that they're going to throw the book at you before you even go in.
Yes, they're not supposed to prejudge you, but they will know, okay, I see that you've been acting up. I see that you tried to attack the process server. And I see that you just went through and denied everything in this complaint. That can be considered.
Wow. All of this is record that's going on, on record that
Yes.
you, the whole journey is being documented.
Mhm.
And that's why I think it's important for folks to file because it's like you're governed, you're overseeing that other party and the actions that are happening. It's a written track record. If you're going to build a case and you
Yes.
need to say, this is happening in my life. This is why I want a divorce. This is why it's important to start that filing as soon as possible so that you can start having that oversight.
Yes, I agree.
Interesting. Okay, so I've always wondered because we talked about that 30-day window that a person has to respond. Is there a benefit in waiting till the very last minute versus getting it in as soon as possible? Like, what do you usually govern? How do you respond or treat when you need to respond for your clients? Do you have a rule of thumb that you follow? Like, I'm going to make sure I get it in by this date, like 14th day, I don't know, whatever works for you. Just wondering about the timeline there.
So, all of our counties are on e-filing, right? So that's electronic filing. You can file from the comfort of your home. And there are two main e-filing systems, Peach Court and then Odyssey.
Okay, yes.
Sometimes those sites can be down for maintenance,
Ooh,
or sometimes they can just have bugs and be down just because the system is having issues.
good point.
If you wait till the last minute and you try to file something on the day that it's due and that e-filing system is down,
And the odds aren't in your favor that
Yeah.
day?
that's it. There's no do-over. That's it. That's all that happens. So that's why I urge people, don't wait till the last minute. Get it in timely. Now, I know we're going to talk about this a little bit later, but in divorces, it's unlike other courts. There's no such thing as a default judgment.
Okay.
So,
Okay, yeah. I do want to hear more about that. So let's say the 30-day, let's say if somebody were to use filing at the response at the last minute, like that 30-day time period, is there a benefit in doing that? Like maybe not giving the other party time to review your information, or I don't know. Is that something that is even
Um,
something to factor in or no?
no, I think most individuals within those 30 days, they're really trying to find counsel. They may be interviewing lawyers. They're trying to figure out what it is that they actually want so that they can have a meaningful response filed with the court.
Okay.
But waiting until that 30th day, all it does is perhaps push the process back a little bit.
Okay.
So with mediation, it can only be scheduled after the answer has been filed or after that 30-day period has passed.
Okay.
There's also with Well, with discovery, it really wouldn't matter. Most individuals are served with discovery. And if you're
Mhm.
served with discovery, then you get 45 days to answer it rather than just 30 days. So
Okay.
there really is no benefit
Yeah.
to delaying the filing
It hurts
of
you
your
more than
answer.
anything. I mean, you're taking a chance. Okay. All right, sounds good. And if the other person needs more time, let's say to collect all of those things and figure out an attorney and such, is there a legitimate way to ask the court for that? What do you normally?
So with divorces, because there's no set time. So I have a divorce that's been pending now.
Uh huh.
My client filed in June. Her husband retained counsel immediately. Counsel entered the case. They did not file an answer and counterclaim until last week.
So what happens if someone files for divorce in the wrong county?
So if
Does it
someone,
get thrown out?
well, it either has to be transferred or it has to be dismissed. If you transfer it, then you don't lose your complete filing fee. So if you recall, a few months back, we spoke about the cost affiliated with the divorce
Uh huh.
and the fact that you have to pay a filing fee. It's about 200, it ranges, but typically about $221.
Okay.
If you transfer, you only have to pay the transfer fee, and that's just what you pay the clerk to transfer the file to the another county.
Got it.
Um, it's cheaper and you save your filing fee, but it can cause delays.
Mm.
If you fail to do so, then it must be dismissed.
Okay, got it. So, and in that situation, let's talk about residency just a
Mm-hmm.
little bit when
Mm-hmm.
filing divorce in Georgia. Do you file in the county where you live? And let's say you're in a separate county from the significant other. Which county do you choose to file in? And we talked about serving the
Mm-hmm.
person. Um, so let's just talk a little bit about that.
Sure. Okay, so if the easiest way for me to break this down is to give an example.
Okay,
Let's
sure.
say my husband and I, let's say we live in Cobb County.
Uh huh.
We decide to separate, and we decide that we're going to separate in March. My husband moves out. I still live in Cobb County, but he moves to Gwinnett County. So long as I serve him and I file the divorce within 6 months of him moving to Gwinnett County, then I can still file in Cobb County where our
Oh,
marital home is.
okay.
However, if I wait until after 6 months, so 6 months and one day of him living in Gwinnett, I must file in Gwinnett County. Mhm.
Interesting. Okay. So that's good to know. That's how that works. So 6 months and 1 day is the
Well,
cutoff.
6 month rule. So if
Mm-hmm.
you wait until after that
Mm-hmm.
6 months,
Mm-hmm.
you have to file in the county where the defendant now resides. If you move expeditiously and file before then you have the ability to file in the county where you all live together.
Got it. What if they move out of state?
Same thing. There's something called a long arm statute. And so, depending on multiple factors, you may be able to capture that party under the long arm statute so that you can litigate in Georgia.
Okay, got it. What if they move out of country? That's
I
a
d-
tricky one because
yes,
now you're talking about international laws, right? And you've got to
yes.
figure out how to get them back here.
Well,
You just wait for them to return?
It depends. It
Mm.
depends on if there are children involved. If
Yeah.
there are children involved, then that means that we have to go through something called the UCCJEA, which is kind of a Child Custody Jurisdiction Act that has step by step rules as to how we determine what's the home state of the child and what country or state can litigate regarding the child. If the other party has left and you're outside of that 6 month period and they are in another country, then we no longer have jurisdiction over that party. And then you would have to file wherever that party is. It just
Yeah.
depends.
I mean, I can imagine a lot of couples go through this,
Yes.
especially if U.S. is not their home country
Mm-hmm.
and they go through a divorce, they go back home
Mm-hmm.
and they may take the children with them.
Yes, and that opens up a lot. That becomes a highly contested custody case where you have to use the UCCJEA. That's an acronym for the Uniform Child Custody Jurisdiction Enforcement Act.
Woo.
Yes.
Good job. This is Maiya Safikovs, y'all. Attorney Safikovs.
Yeah, so that's when you get into those
Yeah.
country battles
Woo.
with children. And then there's something called the Hague Convention. And so that's a very scary territory.
Okay.
And so if you are dealing with that, you definitely want to have an attorney. That is not something that you need to print off forms online and go and file them at the courthouse.
Right. Absolutely. All right. And then last thing I want to ask you is I've heard of this thing called county shopping, where
Yes.
people try to find a most favorable county to file divorce in.
Yes.
I don't know how this could be a real thing, but if you could just tell me, have you heard of this? And are there really counties that are better?
Yes, depending on who you are in the litigation. So, for example, there are some counties that are known to be more liberal, more father-friendly as it relates to custody. There are some counties that still have alimony, and that's going to be part of the judgment. Our guidelines for child support equalize everything across the board, so it makes sure that we're all uniform.
Okay.
There
So
are
child support is going to be the same no matter for the entire state.
Yes,
Okay.
very objective. Our child support calculator is. There are some judges, even within a county, there can be some judges who are more liberal or more father or mother friendly than even their counterparts that are just right next door to them in the same courthouse. So it just depends. Our rules prevent county shopping because you have to be a resident of the county to file,
Yeah.
or your spouse has to be a resident in that county.
Yeah,
Now,
that
if
part.
you manipulated and you knew that your spouse was going to be filing for divorce, I guess one could.
Honey, let's move. Don't
Well,
ask why.
Well, and I'm not giving out. I'm not trying to tell people what to do, but they could.
We're not at all listening.
Yes, they could move to another county and stay in that county for over 6 months.
So that's county shopping.
Yes.
So if you're the other party and you're like, I know that this person is going to file divorce against me. I'm a father. Let me move to a father-friendly county.
You need to go to Fulton County.
Fulton County?
Yes. Yes.
Really?
Fulton County is an extremely liberal county. Fulton County is a parent-friendly county.
Okay.
Where all of the judges, the judicial philosophy is that the children need both parents in their life. And
I love that.
Yes. And so there's no presumption. Statewide, there's not supposed to be a presumption that a mother is a better parent than a father. They're supposed to be on equal footing. Fulton, that's apparent because in a custody matter, either party could walk out with custody of the child. But the parent who does not have primary physical custody, that parent's visitation is going to be extremely liberal. Whereas, weekends typically are defined as Friday to Sunday. A Fulton County weekend at minimum is usually like a Thursday to Monday.
Wow.
Or sometimes a Thursday to Tuesday. That's standard.
Wow. That's
So if
almost
you're a
half the
father,
week.
you go to Fulton.
Yeah, that's great. Okay, that's good to know.
Yes.
Wow, so this is a great episode. I really appreciate you
Thank
sharing so much
you.
information.
Thank you.
Everybody stay tuned because our next episode is going to be even better. This is Attorney Maiya Safikovs, family law attorney, and I'm MaryJ, divorce realtor, and this is Uncoupled.